Welcome to part 2 of the Missouri Constitution as we enter week 8 of American government. We're continuing our look now at the Missouri Constitution and the government that it creates. In this presentation, we've already covered the first 5 articles. Now we're going to look at the rest of the document and also take some time to examine local government in Missouri. As we will see shortly, local forms of government are created by state governments. Article 6 deals with types of local governments allowed in Missouri when we're looking at the Missouri Constitution. Well, we're going to spend some time at the end of the presentation looking at local governments and how they're set up and that kind of thing. And so we're not really going to discuss this article until the end, and so we will save that and hang on to it for a little bit later. Article 7 deals with public officers in the state of Missouri and covers some various different requirements for elected officials within the state. Probably the most interesting section deals with the impeachment of those officials. Impeachment is a process for removing an elected official from office once they've committed some kind of crime while in office, or if they're guilty of some other kind of misconduct that makes them unfit to continue as a public leader. And so we do have a process for that. There's a process at the federal level too. We didn't really spend any time on that talking about it. The book covered it, but in fact, 2 American presidents, Andrew Johnson right after the Civil War and Bill Clinton in the 1990s, were impeached, actually. They were not, however, removed from office. And so that process is used once in a while to try to kick somebody out of office when they do something naughty while they're an elected official. But we certainly have a process for that in Missouri. In Missouri, elected officials in the executive branch and judges are subject to impeachment proceedings. The grounds for impeachment include crimes, drunkenness, neglect of duty, misconduct, and acts of moral turpitude. That's an old-timey kind of phrase that deals with something that's really just nasty and kind of, I don't know, the lowest of the low. You know, you're swindling little old ladies out of their life savings or something. You know, moral turpitude just deals with, you know, kind of the most evil of heart you can imagine. So if you do something this bad, you can get kicked out of office, the Constitution tells us. Well, the actual process of impeachment is a 2-stage affair. In the first step, there's an article of impeachment introduced into the Missouri House of Representatives. And so somebody in the House will get mad enough at this elected official to try to kick them out of office and will introduce an article of impeachment. And this is just a resolution that accuses an elected official of some kind of misconduct, basically worthy of getting them kicked out of office. The House will then debate that article of impeachment and vote on it. If a simple majority vote for the resolution, then we say that the official has been impeached. And they haven't been removed from office, but we'll say that they are impeached. And so we will have further proceedings to see if we will remove them from office. And they're not kicked out yet, though. First, they will have to face a trial, where they will have the opportunity to defend themselves against the charges that were raised in the article of impeachment. So the second step in the impeachment process differs depending on which official we are talking about who is being impeached. If the official in question is not either the governor or a member of the Missouri Supreme Court, then there will be a trial held in front of the Missouri Supreme Court. The court will hear the evidence from both sides. After hearing the case, then the members of the court will take a vote. If at least 5 of the 7 justices vote to convict the official of misconduct, then the official will be removed from office. If less than 5 justices agree, then the official will remain in office. And so if they vote and it's 4 in favor of impeachment, then the person gets to stay in their office and they do not get removed. The trial stage of the impeachment proceedings differs a little bit if the official in question is in fact the governor of the state or a justice of the Supreme Court of Missouri. In that case, a trial will not be held in front of the Supreme Court. Of course, it would be hard for them to fairly judge one of their own if it's a member of the Supreme Court, or the governor who had a role in appointing them to office is apparently the fear there. So instead, the Missouri Senate will select a panel of eminent jurists, which means some really respected attorneys, basically, or judges, and they will decide the case. This panel will consist, as we said, respected lawyers and judges who are not on the Supreme Court, and so they will sit in judgment and hear the evidence. The system works somewhat similarly at the federal level, and I'll say just a few words about this now, and we didn't look at it back when we were talking about the U.S. Constitution, but it's kind of interesting, similar to the Missouri system. If the President of the United States was going to be impeached, the House would adopt articles of impeachment, and we'd have a trial in front of the Senate. The senators would vote whether or not to convict, and presiding over the whole thing would be the Chief Justice of the U.S. Supreme Court. And so it's kind of comforting, I guess, to know that we have a mechanism at all levels of government for getting rid of corrupt officials. If somebody is in office and being really naughty, we have a way of kicking them out of office. Article 7 also deals with the problem of nepotism, which is the practice of hiring people related to you for government jobs. And the Missouri Constitution takes a very dim view of that. If state officials hire someone related to them within 4 degrees of blood or marriage, and they are found guilty of nepotism, they are required to surrender their office. And so if you're just hiring somebody because they're related to you and not because they're qualified, that can get you in big trouble. And this is just an anti-corruption provision designed to keep state officials from hiring those who are closest to them but not necessarily qualified to do government jobs. Article 8 deals with voting and elections. And this article kind of deals with an important issue because at the bottom of the system we have voters going to the polls and selecting our officials and voting on laws and referendums and initiatives. And so that's kind of important to figure out who gets to vote. And that's the first thing that it does. Each state is allowed to determine the qualifications for voting. So long as it doesn't violate a federal constitutional right, such as a racial discrimination or gender discrimination or something like that, the state can figure out who is qualified to vote. So in Missouri, a qualified voter has to meet the following qualifications. They have to be at least 18 years old, a resident of the state for at least 30 days, which isn't very long at all, not convicted of a felony, and mentally competent. And so if you meet those qualifications, you can be qualified to vote in the state of Missouri. Notice, I'll take this time to mention this, if you are convicted of a felony, you lose the right to vote. And you lose other rights too. Convicted felons cannot vote unless they go before a judge and have the felony removed from their record and civil rights restored. And you also lose other rights. You can't own a gun, for example. Despite the Second Amendment, if you're a convicted felon, you've given up that right. And so if you commit some kind of felony, that's bad news and that can follow you for the rest of your life. So certainly keep that in mind if you're thinking of committing a felony. Article 8 also guarantees that we'll have the Australian ballot in Missouri, which of course is the secret ballot, so people won't know who you voted for. Another interesting provision is that a person on their way to vote can't be arrested unless they are committing a felony or a breach of the peace. Why in the world would we have that provision in there? Well, it's designed to keep a corrupt government from arresting people before they can go cast a vote. And this would be a tool that dictatorships might use around the world to intimidate voters who might be voting in opposition to the ruling party. They'll arrest them for something on their way to the polling place, and we don't want that to happen in Missouri, and so this is put in there. And so if you actually get pulled over on your way to cast your ballot, you have a constitutional right to go vote before you're hauled off to jail unless you are committing a felony or breach of the peace. Doesn't mean they can't arrest you, but they have to let you go vote first. And so that's kind of interesting. Also, members of the General Assembly have a similar protection if they're on their way to go vote in the legislature. That can't be arrested. They can't be arrested either, unless it's probably some kind of serious violent thing or something. And that's just to keep them from being kept from voting by a corrupt police force or something like that. So they have similar protections there. So kind of unusual and interesting that's buried in there. Article 8 also contains a provision that was ruled unconstitutional by the U.S. Supreme Court, and that was an attempt to place term limits on U.S. congressmen and senators from Missouri. Remember, we do have term limits on our members of the General Assembly, the state representatives and senators, but voters tried to pass a referendum that would actually place a limit on the number of times a person could run for U.S. Congress or U.S. Senate if they're representing Missouri. And the U.S. Supreme Court ruled that this was an impermissible attempt by Missouri to place limitations on who could serve in the federal government. In other words, the state wasn't staying in its lane here. It was trying to control who was in office at the federal level, and that's not proper for a state to do, and so that was found unconstitutional. And so we have that provision in there, but it has no effect because the U.S. Supreme Court has ruled that it's unconstitutional, and so we just basically ignore it. And so that's a great example to demonstrate if there is a provision of a state law or a state constitution that conflicts with the U.S. Constitution, it will be found to be invalid. And so that certainly was. Article 9 deals with public education. And this section constitutionally requires the state of Missouri to provide a free public education to kids in grades K through 12. And What it says is a general diffusion of knowledge and intelligence being essential to the preservation of the rights and liberties of the people. The General Assembly shall establish and maintain free public schools for the gratuitous instruction, that means free, of all persons in this state within ages not in excess of 21 years as prescribed by law. Well, education is one of those responsibilities that's usually left to the states to deal with, and the importance of education is here enshrined for all to see in the Missouri Constitution. That's actually a departure from the philosophy of our founding fathers, and in their day, really no one was arguing for a right to an education. If you could afford an education, you got it. Most people weren't rich enough, and so they didn't get educated. A free public education was actually a development of the Industrial Revolution, when the manufacturing industry started to need large numbers of educated workers. People started talking about, well, let's just make everyone go to school. And so that was kind of the middle of the 1800s that this developed. But anyway, it's become such an important part of our society that now it's enshrined in the Missouri Constitution. Article 9 also deals with higher education and also public libraries. It talks about the state university, which is the University of Missouri system. And the legislature is also empowered to set up other institutions of learning as it sees fit, such as Crowder and other schools around the state. Article 10 deals with taxes. And remember that taxation is a concurrent power. Both the federal and state governments can tax us. And so, lucky us, I guess. Missouri has sales taxes and a state income tax to raise funds to pay for the operation of the state government. Article 10 also gives the power to tax to local governments. And so we can be taxed at the national, state, and local levels. Aren't we fortunate that that is the case? Article 11 deals with corporations, and we'll just briefly talk about this. Every state is responsible for regulating the corporations and other business entities that are formed and do business within its borders. And a corporation is really kind of an odd thing. It's really a legal fiction. It's legally considered a person, although it is really nothing more than a collection of papers that says that it exists. And so we just kind of make up this legal person, Acme Incorporated will have kind of legal rights, but it's not really a person, but it's a legal person, and so kind of an odd situation. A corporation can own property, can sue and be sued in its own name, it can hire employees, it can do all kinds of other things that a regular biological person could do. The basic idea behind a corporation is that investors will be able to take some of their money and start a business without being personally liable for the corporation's debts. And as an example of that, let's say you invest some money in starting a widget factory, but the widgets turn out to be defective and start exploding and killing people. Okay, well, the company is sued and goes bankrupt. You don't want the people suing the company to come and take your house away to pay the claims because you invested some money in this company. And so to protect you from that, we can start a corporation. And a corporation will kind of shield the owners. The people who are suing the company can seize the property of that corporation, but they can't get the personal assets of the people who invested money to start that company. And so that's basically why we do this, because we want to encourage people to invest money in businesses, because businesses create jobs and invent new things and pay taxes and do all kinds of cool stuff. And so we will want to provide some kind of protection to people so they're not worried about unlimited liability in a situation like that. Well, corporations are entirely creatures of state law, and they couldn't exist at all if the General Assembly hadn't passed laws saying that corporations could be set up in the state. And so that is handled entirely by the General Assembly creating these laws. And a state law sets the limits on how corporations are formed, what they can do, tells us how to deal with corporations formed in another state, which we call foreign corporations. And if they want to do business in Missouri, they have to register with the state government and jump through some hoops. And thanks to Article 11, the General Assembly has the power to do all this stuff, regulating the activity of business entities. Most of the regulation is actually carried out by the Secretary of State's office. So that official in the executive branch, who's a statewide elected official, deals with most of this. Any kind of well-written constitution is going to provide a means for amending the document later to fix any kind of mistakes that came up, or to add things that deal with problems that didn't exist when the document was originally written. And Article 12 does that in the Missouri Constitution. It has some ways of amending the document. Remember that the Articles of Confederation at the beginning of U.S. history didn't have a very good mechanism for making changes, and so that was one of its key weaknesses. And so it's important to have a way to fix those kind of mistakes and add in things that we didn't think about when we originally wrote the document. And the Missouri Constitution does that really in three different ways that the Constitution can be amended. First, the General Assembly can propose an amendment, and if it passes both houses by a simple majority vote, it is then put to a referendum of the people. if a majority of the voters agree to that amendment, it is then ratified and becomes part of the Constitution. So that's pretty simple. Remember that amendments to the Missouri Constitution are not tacked on at the end. Instead, they edit the existing text of the document, and they may add new provisions as well. And so they can just make those changes in there, but we won't see a numbered list of amendments at the end. We'll just edit the document as it exists. The second procedure that we have for amending the Constitution is the initiative process. We talked about that already, but people who want to amend the Constitution just circulate a petition with the proposed amendment on it. If they gather enough voter signatures, then it will appear on the ballot. And getting actually an initiative on the ballot can be kind of a big task. And you have to have enough signatures to equal 8% of the people who voted in the last Missouri governor's race. And so that's usually quite a few people. And so that will take a lot of work, maybe some time and expense as well to gather those signatures, but you can do that. If the proposed amendment gets on the ballot, it will become and gets a simple majority vote, then it will become an amendment to the Constitution. And so the people can just initiate these changes to the Constitution if they want to through this process. The third way to change the Missouri Constitution is kind of interesting, a little bit different than anything else that we've looked at previously. There will be a ballot question on during an election every 20 years from 1962, every 20 years after that. And there's a ballot question that appears during a Missouri election. And the question will ask the voters of Missouri if they would like a constitutional convention to be held to revise or amend the state constitution. If a majority of voters say yes, then the governor has to call for elections for delegates to a state constitutional convention. The convention will then meet at the state capitol and propose changes. And the convention there can either propose amendments to the Constitution that exists, or it can propose that the entire Constitution be scrapped and we start over with a brand new Constitution. So that's kind of unusual because the Missouri Constitution provides a mechanism for replacing itself. So kind of unusual there to think about the document, would provide a way to do away with it, but it does. So whatever changes the convention recommends are put to a vote of the people in a special election. If a majority of voters approve the changes, then the new or revised Constitution takes effect. Article 13 that we're going to look at now, very briefly, in the briefest possible way, is a snoozer. And so we're not really going to go into detail about it. Not that the rest of the Constitution is all that interesting, maybe, to you, but this deals with various items concerning the compensation and benefits of public employees. So for our purposes, it's really not that important. So in a nutshell, we've looked at what's contained within the Missouri Constitution. And now what we're going to do is take a closer look at local government in Missouri. We've looked at the other two levels now, so we're going to spend some time looking at local government. So we've looked at the national level, the federal government, we've looked at the state level, the Missouri Constitution. There's one level that we haven't yet examined in this course, and that is the local level of government. And by that we mean cities, counties, school districts, special road districts, other governmental units beneath the state level. Local governments differ from the other layers we've looked at because they have no sovereignty. That means that they do not have any ultimate legal authority in any area or any respect whatsoever. Remember that our federal system provides that the federal government is supreme in some areas, such as foreign policy, national defense, interstate commerce, those kinds of things. And state governments are supreme in other areas, such as police powers, keeping law and order on the streets, and that sort of thing. And so they kind of split up those ultimate legal powers. Well, our federal system provides both the federal government and the state governments with some level of sovereignty. They have that ultimate legal authority. Local governments, though, have none of that. They have no independent existence on their own. They are entirely entities created by the state. And so the state can create them, it can change them, it can abolish them however it wants to. The only reason we have local governments is because the General Assembly passed laws allowing them to exist. And so it can change the procedures that they follow at any point in time. It can abolish every local government tomorrow if it wanted to. And so they have no independent legal existence. They exist only because the state government wants them to. So local governments simply have no power or legal authority that the state has not let them borrow. And so they have no sovereignty. And so that kind of sets them apart from the other layers that we have looked at. On the national level, if the Constitution is silent about a power of government, we automatically assume it belongs to the states, and we've looked at that in the past. Well, at the local level, if the state doesn't expressly say that local governments can do something, that means they can't do it. And they only have the powers that are explicitly given to them. One of the most familiar forms of local governments are cities, and we will spend a little bit of time looking at how those governments are structured. Well, cities begin when enough people living in a particular geographic area get together and want to start a city. One of the most common ways to do that is by adopting a city charter, which is kind of like a constitution for city government almost. And so people will get together and adopt that. If we have a group of at least 5,000 people in a limited area getting together and writing a charter, they can take a vote on whether they want to create a city based on that charter. And so there's a procedure for that. If a simple majority vote for the charter, a city is born. There's quite a bit of freedom in terms of what the charter can say about how the city government will be set up, but it cannot conflict with any state law. And so, there's different ways that a city can start, but, a city can actually start itself in this way by adopting that charter. So there are different ways that a town can get set up or a city, but that's one way it can happen. And Missouri's Constitution provides for this in Article 6. And laws passed by the General Assembly define how city governments can be organized and the powers they can have. And so we're going to look briefly at just some different forms of city government so you can kind of see how they are structured and how they are run. The first form of city government we're going to look at is called the mayor-council form of government. And this is really the most popular one in the state of Missouri. Over half of Missouri cities have this arrangement. It looks like this. At the top there, we have the voters, who are the ultimate authority. And they get to vote on a city council, and who's going to serve on that council. They will get to choose a mayor. The mayor then controls the various city government departments, like the police department, the fire department, the parks department, whatever other departments the city might have. Just like the people have the ultimate power in all levels of government, power ultimately flows from the voters in this system. The people then elect that mayor, who's the chief executive, kind of analogous to the president or governor on the state or federal level. And so they kind of are the ultimate decision maker in the city government, supervises the other city employees. And if the city has a police or fire department, they will answer to the mayor. The mayor is also ultimately in charge of city services, like the street department, the parks department. And so kind of the chief executive officer of the city, basically kind of like the governor's in charge of the state, the mayor is in charge of the city. Well, the people also elect a city council, which is composed of representatives from around the city. Cities can do this different ways. They often divide themselves up in districts called wards, and there may be one councilman from each ward. Sometimes they will also have councilmen which are elected by the entire city, by the voters from all over, and they're called at-large councilmen. So they're not tied to a particular ward, they just represent the whole city. And the city council meets together, has the ability to make laws known as ordinances, which constitute the body of law within the city. And so it's kind of like they're a mini Congress or a mini General Assembly, and they can create laws called ordinances, which are the law within the city boundaries there. They often pass ordinances on things like zoning, what kind of building you can build in a particular spot, regulating commerce, spending city money for various projects. And so they will get together and talk about those things, debate them, and pass these ordinances. This model is very popular. It works in cities of all sizes. And once in a while, a city's form of government will change. And so I haven't updated this in a while, so it could have changed. But at last check, Knoll, Alba, and Tulsa all had this form of government. So cities of quite a bit different size there. Alba is just tiny, and Tulsa is quite large. And so this works in different cities of different size. Another form of local government we have is called a commission. And this was kind of came from the early part of the 1900s. It was pretty popular back then. Now it's fairly rare. But here's what it looks like. We have the voters at the top, of course, and then they select different commissioners. And the city is run by these commissioners who are elected directly by the people. Each commissioner is in charge of one specific area. So here we have a commissioner of public safety who might be in charge of the police and fire department, commissioner of administration who might be in charge of paying the bills and that kind of thing, commissioner of public works, who might supervise the street and water departments, for example. And each commissioner acts as a chief executive of his or her specific area. So we don't have one executive running the whole city. We have different executives running the different areas of the city government. And so that's how that's set up. However, the commissioners have an additional role. They meet together collectively as a group and kind of act like a city council. And so they can get together and have that legislative power. They can make ordinances. And so they play a dual executive legislative kind of role. And so that's a little bit different than we might have seen anywhere else, really, in our studies, to have those two roles combined. We're so used to seeing the separation of powers. But so this form of government's a little bit odd. Isn't all that popular anymore, however, it is around. Last I knew, Monette followed this model. And so it does exist, it's just not as popular as it used to be. We also have a form of government called council manager. This began to be popular around the turn of the 20th century. And most cities that were chartered and follow that procedure we looked at briefly earlier have this form. And the arrangement looks like this. So we have the voters at the top. They select a city council who hires a city manager who runs the various city departments. And so voters give that legislative power to the city council. The council then hires a city manager who acts as the chief executive. The model that we use in this system kind of mirrors that of a large corporation, basically. The voters are like stockholders who elect a board of directors, which would be the city council, and who then turns around and hires a CEO, which is the city manager. So it kind of models what big companies do a little bit. The idea behind this structure is that large cities are very complicated organizations. You don't want to just elect, some mayor, who's a businessman or whatever. You need a professional in charge of running the place. That whole, electing the local businessman to be the part-time mayor, that might work in a small town. But in a large city, you need someone with a certain skill set to be able to manage the city and all of its employees full time. And so city managers are professionals. They are hired guns. They usually have a master's degree in public administration, and they are hired by a city council because of their management skills. And so they are professional city managers. And so they will get hired by, different cities to run the city. And so we have that professional skill set in place, and we see that as important in a larger town, usually. One good thing about this model, it clearly separates the legislative and executive powers. The commission kind of merged those together. Well, this kind of keeps that separate. Critics, though, point out that people can't choose the person running their city. That city manager is determined by councilmen who are elected, but they have the power to hire whatever city manager they want, so the people don't really get to choose who's running their own city. So this is less democratic than letting people elect a mayor who acts as chief executive. Cities with this form of government do have a mayor. You may have noticed on that chart that there was no mayor, which is kind of odd. But the council will vote and select one of their own members to serve as mayor. And a lot of times that'll just kind of rotate from one city council person to the next, and each one will take a turn serving as the mayor. And in practice, that doesn't involve a huge amount of work because the city manager is doing all that day-to-day work of running the city. And so what the mayor does is kind of act like the head of state. And so they will show up at ribbon cuttings and things like that and official city events and represent the city, in various public functions. But the city manager is the one that's actually doing most of the work. Local examples of cities using this model include Joplin, Neosho, Springfield, and Nevada. So it's a pretty popular one, especially for the larger cities and towns. And so it's fairly effective, and hiring a city manager who has that professional skill set certainly would have its advantages. Another form that we have is called the Mayor Council Administrator form of government. And this is one form that's kind of an odd hybrid. Basically, it's a modification of the Mayor Council form, but it's a little bit different. And so we have the voters who get to vote on both the mayor and the city council. And so they get to choose their own legislative branch, basically, and their own executive. But then the mayor and the council work together to supervise a city administrator, who's another professional who runs the town, and they supervise the police, the streets, the water, all these other city departments. In this model, both the mayor and the council are both directly elected by the people, and so that's nice. We like to feel like we're in a democracy and we get to choose the city's leadership. However, we also end up with a professional manager because the mayor and council will hire a city administrator who is much like a city manager that we looked at in the last form. This is a professional who has a college degree and knows how to run a city. This person will be a professional and with that skill set needed to manage a fairly large city government. So we will have a compromise basically between the mayor, council, and the city manager forms of government. It's just kind of a hybrid, like we were saying. So in this model, the city administrator will answer to the mayor and to the city council. And so they will have multiple bosses, basically, but they're in charge of running the city on a day-to-day basis. Some local examples of this form of government include Carthage, Webb City, Lamar, and Carl Junction. Again, at last check, they can change forms from one to another. But last I knew, they were doing that. So cities can and do change forms. So don't take this to the bank. But at one point or another, those cities were using this form of government. Well, changing forms from one to another can actually make sense when the city grows in size, for example. It might start out as a little bitty town and just electing a mayor off the street, was fine. But then if it grows into a larger city and has more employees and more problems, then we need a professional city manager. So state law provides procedures by which cities can change from one form to another. And so that can be useful sometimes. Well, that's it. That's all I have for the Missouri government and local government and all other kinds of government. So I'll just take this opportunity to say it was great having you in class. I always enjoy teaching this course, getting to know you all a little bit through the discussion board and other ways. And so I wish you best of luck in the future. I hope that you learn some stuff, maybe some stuff you'll take with you. I hope that you won't forget everything after the final exam. I hope that you will maybe take a little bit that you learned and become a more educated citizen, and know how your government's working, keep an eye on it, certainly participate by voting and those other things. And so, great getting to know you a little bit. Hope the class at least wasn't as painful as you might have feared going in. Wish you the best of luck in whatever life has in store for you, and you take care. I'll see you down the road.